2 tahun yang lalu. 2 tahun yang lalu, bulan 7, 15 hari bulan. Itu adalah satu tarikh yang tidak kita akan lupa selama-lamanya. Saya juga nak mengucapkan ataupun mengumumkan kehadiran Datuk Wisam Musa Abdul Gani Patail. Terima kasih kerana hadir. Seperti yang saya katakan tadi, 15 Julai 2009, tragik. Satu peristiwa hitam dalam sejarah Malaysia. 15 of July, 16 of July, a black day in Malaysian history. Why? Because that day, that fateful day, will forever remind us of how weak certain institutions are in this country. It will forever remind us of how strong the people of Malaysia really are. And it will always remind us of how vulnerable all of us here can be if we do not stand up together and demand for justice, for a change, a total revamp in the system which exists, which will make sure and ensure that this kind of a tragedy does not befall any other Malaysian in future. Tuan-tuan, tarikh tersebut akan mengingatkan kita akan kelemahan-kelemahan yang wujud di dalam institusi-institusi tertentu di Malaysia. Yang akan juga mengingati kita berkenaan dengan betapa kuatnya dan betapa berpaduan di antara rakyat Malaysia dan bagaimana kita perlu bersatu untuk menuntut perubahan, menuntut keadilan. Bukan saja untuk Teoh Beng Hock, tetapi untuk semua anak Malaysia, dengan harapan apa yang berlaku kepada Teoh Beng Hock tidak akan berlaku kepada semua anak kita dalam masa akan datang. And when I speak tonight, I speak not only of Teoh Beng Hock, I speak with a heavy heart. We have cases which happened recently, the case of the late Sarbani, cases which involve Aminur Rashid, Hogan. These are names which will forever remain in our minds. Earlier I said that this date will remind us of weaknesses in institutions that exist. What did I mean when I said that? After 2 years, we still fill up this hall asking ourselves, what happened to Teoh Beng Hock? Doesn't that tell you that something is tragically wrong in our system? After 2 years, a police investigation, an inquest, now an RCI, we still come back here and ask questions. What actually happened? The RCI has come up with a report which I think baffles us all. I will come to that in a moment. But what does the RCI also show us? Does it not show us that our police are not capable of doing their jobs? After 2 years, you have an RCI that tells us, yes, there was interrogation which was harsh, aggressive. Yes, certain officers of the MACC are involved in various ways, responsible. Why couldn't the police tell us this 2 years ago? Why did they make the family of Teoh Beng Hock, why did they make Malaysians go through those 2 years of pain? Only to tell us this? I ask you, do you think the police force in Malaysia is up to mark? Do you think you can trust the police force in Malaysia to investigate cases and come up with justice when something goes wrong? Do you think we can trust the men in blue to expose their own people when things like this go wrong? And if we can't trust them, and it's not me who's saying this, it is the commission that says it, the wall with blue. The question is now, weakness in the police force. Are any police officers going to stand up and take responsibility? Will any police officers stand up and accept that their investigations 2 years ago was not up to mark? No, this does not happen in Malaysia. Other countries, the head of department will resign as a mark of honor. But in Malaysia, no. In fact, I won't be surprised if we see promotions. But this is what Malaysians are sick and tired of. And this is why we want change. The police force left standing, bewildered, not knowing what to do. After the inquest, the coroner came up with certain findings. Right or wrong, separate matter. But certain findings were made. At that time, I said that the police had enough to make arrests. To arrest certain officers, to investigate. But did that happen? No. No. Then they have the RCI. And let me come back to the inquest. You talk about the police. Now you talk about what happened at the inquest. At the end of the inquest, when they realized, and when I say when they realized, I mean the MACC. When the MACC realized that all was pointing towards them, when this became apparent, suddenly there was the production of a note. 1 year after a trial, we are in court every day, asking questions. What happened? Tell us. After 1 year, the prosecution comes up with a note. And when I asked them, why did it take you 1 year to produce this note? We forgot. Well, I suppose, it's an honest answer. I'll give them that. At least they're being honest. But that reflects on the kind of people we have in the AG's chambers. Now let me be blunt about it. I think when that happened, the Attorney General of Malaysia should have accepted responsibility and resigned. How can you allow such a thing to happen in a case which has gripped not only the minds of all Malaysians but of people all over the world? But of course, that doesn't happen in this country. And then in the process, you have the Minister of Law, Nazri. I'm sure you all know who he is. It's difficult not to know who Nazri is in this country. What does he do? Openly saying, while the inquest is in progress, that our main witness is lying. You know, in Singapore we have the minister mentor. I think in Malaysia we have a minister mistake. And this is Nazri, for the kind of mistakes he keeps making. And then we have the RCI. The RCI was set up, they investigated, and they came up with a report. What does the report say? I take you to paragraph 119, the famous paragraph 119. Decision on second term of reference. Having considered all the evidence in its entirety, we found that TPH was driven to commit suicide by the aggressive, relentless, oppressive, and unscrupulous interrogation to which he was subjected to by certain officers of the MACC who were involved in the ongoing operation by the Selangor MACC on the night of the 15th and into the morning of the 16th. Very strong remarks. We found, and this is after considering all the evidence in its entirety, we found that Teoh was driven to commit suicide by the aggressive, relentless, oppressive, and unscrupulous interrogation by certain officers. If you were to look at this report, you will find that the Commission does not actually know what happened after 3:30 in the morning until about 6:30 or 7 in the morning. So let me ask you a simple question. When you say interrogation was, and I repeat, aggressive, relentless, oppressive, unscrupulous, then you would expect that the person will break there and then, because even they say the last straw that broke the camel's back. But the point is this: what happened for the next 4 hours, nobody knows. How did Teoh Beng Hock exit the building? There is no actual evidence. So how do you know he committed suicide? Simple question. People ask me this question too. After relentless, aggressive, oppressive, unscrupulous interrogation, rest first for 4 hours, and then get up and just say, walk to the window and jump out. Do you see the lack of connection? Where is the evidence to suggest suicide? When you make a ruling like this, it has heavy, very serious implications. It impacts the family. It is something that the family will have to live with for the rest of their lives. And that's the reason why the courts have continuously held that when you make a finding of suicide, that finding must be supported by evidence. Now in this regard, I would like to read to you certain passages. I'm sure Justice James Wong knows this case. Passages in the case of Derek Selby, deceased. A Malaysian case as far back as 1971, an inquest. Now what did Justice Sharma say? Now he said this: all that had been proved was that it was not impossible that the deceased had committed suicide. If it could have been shown that he actually had an intention to commit suicide, it would be more probable that he in fact did commit it than if he had no such intention. A person may have an opportunity to commit suicide, but that does not mean that he committed it. Makes sense, right? He goes on to cite an English case, Lockley. Again, coming back to this, the conclusion stated that those passages are nothing more than the expression of a theory which is attractive in its probability. It is not a probability, however, which determines verdicts, but prove facts. And its facts must justify a specific verdict. Based on this, Justice Sharma had held, the law is that suicide is not to be presumed. This is the law. And this is what the coroner stood by at the inquest. He directed himself according to these principles, and he ruled that it was impossible on the facts to come to a finding of suicide. Now we come back again to the RCI report. What are the facts? What are the facts on which the Commission held that there was suicide? The note, you will remember that note, that alleged suicide note, which became controversial at the inquest, that was produced even here. But what did the Commission hold? The Commission rejected the note. It was ruled inadmissible. So, no. All you have is 4 interrogation sessions. Interrogation sessions where Teoh is said to have looked tired, naturally. If you are questioned overnight, naturally you will be tired. Didn't talk too much. Of course, if you are tired, normally you don't talk too much. These are the kind of facts produced in support of this finding. Then, of course, they go on to speak of the findings of Professor Mullen. Professor Mullen was asked to come to Malaysia from Monash University, and the Commission requested him, or requested his help to come to a finding on Teoh Beng Hock's mental state. Now, if you look at the report, it would appear that the Commission placed weight on Dr. Mullen's report. It would appear that they relied heavily on his report in concluding that there was a tendency on part of Teoh to commit suicide. given the nature of treatment that he was subjected to. But let us look at Professor Mullen's report and what it said. Now, ladies and gentlemen, I got a copy of the report here, and I want to read to you certain passages from this report. Now, this is what the report says. Of course, it goes into detail of Teoh's state. In fact, it talks about how it is, and I read. In brief, it is my opinion that Teoh Beng Hock was firmly in the lowest risk group for suicide when he was taken into MACC custody. Most of us fall into the lowest risk group, where the chances of killing ourselves are very small. This is Professor Mullen's report. He goes on. If the Commission does not give credence to the note being a suicide note, this is the note that I said was rejected, in my opinion, this greatly reduces the probability that Teoh Beng Hock killed himself. If the Commission were also to accept the claims that Teoh Beng Hock was cooperative, not showing obvious distress, and willingly chose to remain in the MACC offices, this, in my opinion, would virtually exclude the chances of Teoh Beng Hock having taken his own life. This is Professor Mullen's report. Lastly, in my opinion, prior to entering custody, Teoh Beng Hock was in a low risk group for suicide. He said this earlier. If he did kill himself, in my opinion, things are likely to have occurred both to undermine his psychological stability and to frighten him literally to death. This is the report of the professor. I have given to understand that an application was made by the lawyers for the Bar Council to call Professor Mullen as a witness in the RCI. You see, ladies and gentlemen, let me explain certain things and how they work in law. An expert can only give you his opinion based on facts that are presented to him. Ultimately, what is important is for you to ask him, to present the facts to him, and then to ask him whether or not he would rule or conclude that there was suicide or otherwise. So the point that I make is this: did the Commission present these facts which they say evidence, I read it again, aggressive, relentless, oppressive, and unscrupulous interrogation to the expert, and ask him for his opinion before coming to a conclusion, as they have done in this book. So, ladies and gentlemen, the reason why I make these points is because I understand. And I will say to you this: after 2 years of fighting continuously, every single day in the last 2 years, Leland, Minky, Mr. and Mrs. Teoh Beng Hock's wife, after 2 years of fighting, this verdict comes to them as shocking. And I think one can understand why it is they find it shocking. And I think most of us Malaysians also find it shocking. Most of us Malaysians ask that simple question: where's the evidence? Convince us and we will believe you. But don't throw it at us and ask us to believe you, because we Malaysians will not believe you that easy. Now we speak of the law. I want to ask you sitting here, most of you here been in this country for long enough, all your lives. What is the purpose of the RCI? What's the purpose of RCI? Why do we go through the trouble? Why do we spend taxpayers' money? Days and days spent. Experts roped in, asked to help. For what? So that we have a booklet. So that we can keep this book with us for the next 10 years and say, yes, anybody wants to know what happened to Teoh Beng Hock? Here, read this book. Is that justice for Teoh Beng Hock? No. Is that what we have fought for the last 2 years? No. And when the report says things like there was use of aggressive, relentless, oppressive techniques during interrogation, the Attorney General says, yes, we will take disciplinary action. You asked us to go through a whole RCI wait for 2 years for disciplinary action, and you expect us to be happy. You expect us to say, Gani Patail, you are the man, very good. That is the reason why we have to change in this country. We have to remove people who do not do their jobs. And we, the people of Malaysia, demand that these people do their jobs. You say that there is no section under the penal code that you can take action. Come here now, debate with me. I will tell you which section. What did the report say? Did the report not say that certain officers did not tell the truth? Didn't the report say that? The report said that certain MACC officers didn't tell the truth. Got or not? No. It's here. Gani Patail cannot read it. Now what does the law say? The law says that if somebody does not tell the truth in a proceeding, and this I will check for him, no problem, then isn't it something that you can charge him with? Section 193 of the Penal Code. It's here. Whoever intentionally gives false evidence. So, you don't charge. Okay, never mind. You say you don't charge. Let me take you to section 330 of the Penal Code. What does section 330 say? And I read it. Voluntarily causing hurt to extort confession or to compel restoration of property. Now this is interesting. Whoever voluntarily causes hurt for the purpose of extorting from the sufferer or from any person interested in the sufferer any confession or any information which may lead to the detection of an offense or misconduct, or for the purpose of constraining the sufferer or any person interested in the sufferer, it goes on. commits an offence shall be punished with imprisonment for a term which may extend to 7 years and shall also be liable to fine. Illustration number 1A. A police officer tortures in order to induce someone to confess that he committed a crime. He is guilty of an offence under this section. I read that passage to you, paragraph 119, many times. Look at the words used by the Commission. Read it again. Aggressive, relentless, oppressive, unscrupulous interrogation. Section 330, clearly applicable. Why not, Judge? Why not? And there's also, of course, a call by Malaysians that perhaps this should be a test case. Charge under Section 302 or 304 if you must. Heavy, yes, I know. I don't know, let the court decide. But as I said earlier, the Attorney General is the only person under our Constitution who has the power to prosecute. And that's why he is called the public prosecutor. It is instances like this that the public prosecutor must inspire confidence in the public by taking action. By taking action when things like a Royal Commission of Inquiry comes up with suggestions. Now I want to say this. If the Attorney General does not take action, if the Attorney General is still of the view that there cannot be criminal proceedings, then the Attorney General must explain to the public, must explain to Malaysians, must explain to the family of Teoh Beng Hock why it is he thinks action cannot be taken. Times have changed. Malaysia today is different. The Malaysians today are more demanding. We Malaysians are more demanding of our rights. We want to make sure that this country becomes a better place, a safer place for us. We want to make sure that what happened to Ahmad Sabani doesn't happen to anyone again. We want to make sure that what happened to Teoh Beng Hock does not happen again. Now, in order for that to happen, the Attorney General must act, and he must be firm, and he must send a message down to the public masses that even the AG's chambers will take action if this kind of thing happens. And I have said this many times, and I say it again. If Abdul Gani Patail cannot provide us with a good explanation as to why no action is taken, then Gani Patail must resign immediately. We have said last week, and I say it again, Bila Malaysia family Teoh Beng Hock is here. Mr. Kapal said to me last week that we must prepare. We must prepare and ready ourselves for an application for judicial review. We are looking into that. But the message that has to be sent is this. We have fought for 2 years. We will not back down. We will not sit back until we see justice for Teoh Beng Hock. And ladies and gentlemen, in ending, I would like to say this. When people like us fight the cause, and here I would like to just mention a special word, an example of what I mean. Mr. Lim Kit Siang, who has not only fought this battle, but fought many battles in his life. The reason why we have the spirit to fight on is because you, the people, give us the inspiration. And I would like to say here this to the family of Teoh Beng Hock, Uncle, Auntie, Menki, Nilan. The people are still with you. We are with you. The fight goes on. Thank you very much.